Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It is a historical and sociological analysis of the legal profession and matrimonial law in the United States. This video does not constitute legal advice, nor does it create an attorney-client relationship. The legal landscape regarding domestic relations is complex and varies significantly by jurisdiction. Viewers are strongly encouraged to conduct their own due diligence and consult with the licensed professional in their specific state regarding any personal legal matters. In the shadows of the gleaming skyscrapers of Manhattan and the palm-lined estates of Beverly Hills, a silent industry facilitates the transfer of billions of dollars in assets every single year. It is an industry built on the wreckage of the American dream, where the most successful practitioners are those who can navigate the volatile intersection of raw emotion and cold, hard math. We often talk about the Great Recession or the tech boom as the primary drivers of wealth redistribution in America, but there is a legal mechanism that has arguably moved more capital between private hands than any market fluctuation in history: the divorce. Specifically, the evolution of the divorce attorney from a social pariah in the early 20th century to a high-powered architect of modern family structure. Consider this. In 1960, the divorce rate in the United States was roughly 9 per 1,000 married women. By 1980, that number had more than doubled to 23. This was not a random cultural fluke. It was the result of a massive legislative and professional shift that turned a niche, often shunned legal practice into the backbone of a multi-billion-dollar service economy in major U.S. cities. Today, we are embarking on a deep-dive masterclass into the historical analysis of the divorce attorney. For the modern U.S. audience, understanding this history is not just about looking at the past. It is about solving the problem of the present. Whether you are navigating your own legal hurdles, interested in the sociology of the American city, or curious about how professional power is concentrated, this analysis provides the blueprint. We will uncover why certain cities became divorce capitals, how the legal strategies of the 1920s paved the way for the high-stakes litigation of the 2020s, and what the historical trends tell us about the potential outcomes of today's most complex domestic cases. This is not a summary. It is a granular look at the professionalization of heartbreak. To understand where we are, we must go back to a time when getting a divorce in a major U.S. city was nearly impossible without a scandal. In the late 19th and early 20th centuries, states like New York had incredibly restrictive laws. In Manhattan, for instance, the only recognized ground for divorce was adultery. This created a massive problem for the wealthy elite who simply wanted to move on with their lives. It gave birth to the first iteration of the specialized divorce attorney, not as a litigator, but as a strategist of the migratory divorce. Because the laws in New York were so rigid, attorneys began identifying loopholes in other jurisdictions. This led to the rise of the divorce colonies. In the 1890s, Sioux Falls, South Dakota, became the first major destination. A New York attorney would advise their client to board a train, move to a hotel in Sioux Falls for 90 days to establish residency, and then file for divorce under South Dakota's much more lenient statutes. The attorneys in these cities weren't just practicing law. They were building an infrastructure. They partnered with hotel owners and local businesses to create a seamless pipeline for the six-weekers, or 90-dayers. This era represents the first time we see the divorce attorney acting as a corporate consultant for personal life, managing the logistics of residency as much as the filings in court. As we moved into the 1920s and 30s, the center of gravity shifted to Reno, Nevada. This is where the divorce attorney truly became a public figure in the American consciousness. While the rest of the country was reeling from the Great Depression, Reno was thriving. Attorneys in Reno pioneered the divorce mill model. They leveraged Nevada's short residency requirements, reduced to just 6 weeks in 1931, to attract the rich and famous from Los Angeles and Chicago. These attorneys were the first to use mass marketing, albeit subtly, by ensuring that high-profile celebrity divorces were covered in the press, highlighting the efficiency of the Nevada legal system. They were selling a product, freedom. The historical data from this era shows that Reno attorneys were handling thousands of cases annually, creating a specialized legal class that understood the nuances of jurisdictional arbitrage. However, for those who couldn't afford to travel to Nevada, the situation in cities like New York remained desperate. This led to one of the darkest and most fascinating chapters in the history of the profession: the era of the collusive divorce. Since adultery was still the primary ground, attorneys often had to facilitate staged evidence. This involved hiring private investigators and even professional correspondents, usually women paid to be photographed in a hotel room with the husband, both fully clothed but in a compromising enough position to satisfy the court's requirement for proof of infidelity. The attorney's role here was a mix of director and legal shield. They had to ensure the evidence looked authentic enough to pass the judge's scrutiny, but was controlled enough to avoid actual criminal charges. It was a high-stakes game of legal theater that lasted well into the mid-20th century. The true seismic shift, however, occurred in 1969 and 1970, and it centered on California. This is where we see the birth of the modern divorce attorney as we know them today. Before this, the legal system was based on fault. One person had to be the villain, and the other the victim. This meant attorneys spent most of their time proving or disproving moral failings. When Governor Ronald Reagan signed the Family Law Act of 1969, which went into effect in 1970, California became the first state to adopt no-fault divorce. This changed everything. Suddenly, the attorney's primary job shifted from proving a moral transgression to managing a complex financial dissolution. The focus moved to community property, asset valuation, and long-term spousal support. This created a massive demand for a new kind of specialist, the matrimonial attorney who was also part accountant and part actuary. In major cities like Los Angeles and San Francisco, law firms began to grow exponentially. They weren't just small offices anymore. They were sophisticated operations with departments dedicated to forensic accounting and child psychology. This era saw the rise of the super lawyer in the matrimonial field, individuals who could command hourly rates that rivaled top corporate litigators. By the 1980s, this trend hit the East Coast with full force. New York finally adopted more liberal laws, and the focus in Manhattan shifted to the valuation of professional licenses and celebrity goodwill. In the landmark case of O'Brien v. O'Brien in 1985, the New York Court of Appeals ruled that a medical license could be considered marital property subject to distribution. This was a watershed moment. It meant that a divorce attorney in a major city now had to be capable of projecting the lifetime earnings of a doctor, a partner at a law firm, or a hedge fund manager. The level of detail required in these cases skyrocketed. Attorneys began employing teams of experts to analyze pension plans, stock options, and the appreciation of real estate in rapidly gentrifying urban centers. This historical trajectory shows us that the divorce attorney did not just appear. They were forged by the changing economic and legislative landscape of the American city. They moved from the fringes of the legal world into the inner circles of power, becoming essential gatekeepers for the wealthy. In major hubs like Chicago, the evolution was mirrored in the court system itself, as specialized domestic relations divisions were created to handle the sheer volume of cases. These divisions allowed for the development of a specific courtroom culture, where attorneys, judges, and clerks all became part of a specialized ecosystem. As we look at these case studies from the past, we see a clear pattern. As cities grew and wealth became more concentrated, the legal strategies became more sophisticated. The divorce attorney evolved from a provider of a simple legal service into a comprehensive manager of a client's future. This transition was not just about the law, it was about the professionalization of the end of a contract. By studying these historical trends, we can see how the groundwork was laid for the current environment, where a single filing in a major city can trigger a multi-year legal battle involving international assets and complex digital holdings. The history of the divorce attorney is, in many ways, the history of how America views the value of the family unit and the price of its dissolution. We are now standing on the shoulders of these early pioneers, navigating a world they built through decades of litigation, legislative lobbying, and tactical evolution. To understand the tactical evolution of the modern divorce attorney, we must first analyze the decade where the profession underwent a radical transformation into financial warfare, the 1980s. This was the era of the high-flying corporate raider and the rise of the ultra-wealthy professional class in cities like New York and Chicago. Before this period, the divorce attorney was primarily a storyteller, focusing on the narrative of who did what to whom. But by 1985, the job description shifted. The attorney became a high-level financial analyst. Imagine if you are a character named Thomas in 1985 Manhattan. Thomas is a successful surgeon who has spent the last decade building a practice while his spouse supported the household. In the 1950s, a divorce would have resulted in a simple alimony payment based on current income. But by the mid-1980s, Thomas's spouse's attorney is no longer looking at his current salary. They are looking at his degree as a piece of property. This shift was crystallized in the landmark historical trend established by the case of O'Brien v. O'Brien. The court's decision meant that the attorney's role was now to calculate the lifetime value of a professional license. This required a level of mathematical precision never before seen in domestic relations. Attorneys began hiring economists to testify as expert witnesses, using complex formulas to project earnings 30 years into the future, discounting them to present value, and then demanding a percentage of that hypothetical future wealth. This was the birth of the enhanced earning capacity claim. For the first time, a divorce attorney in a major U.S. city had to understand the time value of money, as well as they understood the statutes of the state. This created a massive barrier to entry. Only the elite firms in major cities had the resources to litigate these points, leading to the concentration of power in a few high-priced boutique firms that could handle the sheer volume of data and expert testimony required. As we moved into the 1990s, the battleground shifted from the valuation of licenses to the discovery of hidden assets, particularly in the high-stakes environment of Los Angeles. In LA, the divorce attorney had to contend with the unique financial structures of the entertainment industry, residuals, points, and production companies that often existed only on paper. This led to the rise of the scorched earth policy of discovery. Imagine a character named David, a high-level studio executive in 1992. His divorce is not just a personal matter. It is a corporate audit. The opposing attorney would issue hundreds of subpoenas, a process known as the paper war. They would demand every bank statement, every expense report, and every credit card receipt from the last decade. The historical data from this period shows that the cost of discovery began to consume a larger and larger percentage of the marital estate. Attorneys realized that by making the process as expensive and intrusive as possible, they could often force a settlement before the case ever reached a judge. They were no longer just practicing law, they were practicing attrition. In Chicago, the focus was slightly different but equally complex. The major legal battles centered on closely held corporations, family businesses that had been passed down for generations. The Chicago divorce attorney of the 1990s became a master of corporate governance. They had to figure out how to value a manufacturing plant that had no public stock price and was integrated into a web of family trusts. This required a deep dive into historical trends of market comparables and minority interest discounts. The attorney had to argue that a spouse's interest in a company was worth millions, while the other attorney would argue that because the spouse didn't control the company, the interest was essentially worthless. This tension created a specialized niche for the attorney-accountant hybrid, a professional who could spend 8 hours a day reading ledgers and the next 8 hours arguing about them in court. Fast forward to the current landscape of 2026. The historical tools of the 80s and 90s have been weaponized by technology, creating a whole new set of challenges for the contemporary attorney. Meet Mark, a tech founder in San Francisco. It is 2026, and Mark's company is about to go public. His assets are not in physical manufacturing plants or medical licenses. They are in pre-IPO stock options, complex crypto assets, and intellectual property that is difficult to quantify. The 2026 divorce attorney in San Francisco must be a digital forensic specialist. The historical trends of tracing money through bank statements have been replaced by tracing transactions through a blockchain. If the attorney cannot navigate a decentralized ledger, they cannot represent a high-net-worth client in a major U.S. city today. The potential outcomes in Mark's 2026 case depend entirely on the attorney's ability to freeze digital assets before they can be moved to a non-custodial wallet. This is the modern iteration of the Reno residency strategy or the New York staged adultery. It is about speed and technical proficiency. In the first 30 days of a 2026 high-net-worth filing, the attorney must deploy digital discovery bots to monitor account activity and issue temporary restraining orders on brokerage accounts that hold volatile assets. If they wait even 24 hours, millions of dollars in valuation can vanish. This has led to the creation of the war room model in major firms, where legal teams work alongside cybersecurity experts and data scientists. The psychology of the high-stakes attorney has also evolved. They are no longer just legal representatives, they are risk managers. In 2026, the attorney must advise their client on the potential outcomes of public exposure. In a world of instant social media virality, a single filing in a major city can become national news in minutes. The historical analysis of celebrity divorces in the 90s showed that the court of public opinion can be used as a lever in settlement negotiations. Today, the attorney manages the narrative as much as the docket. They must coordinate with PR firms to ensure that the client's reputation, which is often their most valuable asset, remains intact through the litigation. What we are seeing is a professionalization of domestic conflict that mirrors the complexity of the global economy. The divorce attorney in a major U.S. city has become an architect of asset protection and redistribution. By analyzing the step-by-step evolution from the simple alimony of the past to the complex valuations of 2026, we see a profession that has moved from the moral to the mathematical. The goal is no longer to find fault. It is to find the money, value it, and capture it. This historical progression tells us that as long as wealth becomes more concentrated and assets become more intangible, the role of the divorce attorney will only become more central to the functioning of the American upper class. They are the ones who define the price of a failed partnership in the modern age, using every historical precedent and modern tool at their disposal. But as the assets become harder to find and the legal fees continue to climb, a new question emerges. What happens when the cost of the fight begins to exceed the value of the prize? And more importantly, how have attorneys developed secret methods to find money that has been intentionally scrubbed from the digital record? We have looked at the visible evolution, but there is an entire world of hidden accounts, offshore entities, and complex trust structures that the top 1% of attorneys use to protect their clients or expose their opponents. In the next part of this deep dive masterclass, we will pull back the curtain on the hidden vault era, the specific tactics used by the world's most expensive attorneys to hunt down assets that technically do not exist on any balance sheet. We will look at the rise of offshore jurisdictions and the secret treaties that even the most seasoned litigators are afraid to challenge. The battle for the surface assets is over. The war for the hidden ones is just beginning. To understand the war for hidden assets, we must first look at the year 1984, which serves as a pivotal moment in the history of global asset protection. While domestic divorce attorneys in cities like Chicago and Miami were perfecting their skills in uncovering standard bank accounts, a new legal frontier was being established in a tiny nation in the South Pacific, the Cook Islands. This was the year they passed the International Trusts Act, a piece of legislation that essentially created a legal fortress. This act was designed specifically to make foreign court orders, including U.S. divorce decrees, nearly impossible to enforce. For the top-tier divorce attorney in 2026, the Cook Islands represent the historical gold standard of what they call the non-recognition of foreign judgments. Imagine if you are a character named Michael, a high-frequency trader living in Austin, Texas, in the current year 2026. Michael has been planning his exit for 3 years. Under the guidance of a specialized asset protection attorney, he doesn't just move money. He creates a complex web of legal entities. He establishes the Cook Islands Trust. Historically, the brilliance of this move lies in the fact that the Cook Islands do not recognize a U.S. court order. If Michael's spouse wins a $10 million judgment in a Texas court, that piece of paper is effectively worthless in the South Pacific. To even begin a claim against the trust, the spouse's attorney must fly to the Cook Islands, hire a local lawyer, and prove their case beyond a reasonable doubt, a criminal standard of proof, in a local court, all while facing a statute of limitations on fraudulent transfer that is often as short as 1 to 2 years. This historical trend of jurisdictional arbitrage forced divorce attorneys in major U.S. cities to become international investigators. By the late 1990s and early 2000s, the battle was no longer fought just in the local courthouse. It was fought through a process known as letters rogatory. This is a formal request from a U.S. judge to a foreign court asking for judicial assistance. However, as any seasoned matrimonial litigator will tell you, this process is notoriously slow, often taking years to produce a single bank statement. This delay is a tactical feature, not a bug. It allows the asset-holding spouse to move funds through a series of shell companies in Panama, the British Virgin Islands, and eventually into the shadows of the decentralized web. In 2026, the hunt has evolved into a high-tech game of cat and mouse. Michael's spouse isn't just looking for bank accounts anymore. Her attorney is employing digital forensic specialists to perform what is known as a lifestyle audit. This is a step-by-step reconstruction of Michael's spending to find the gap between his reported income and his actual standard of living. If Michael claims he earns $200,000 a year but historical data shows he is spending $50,000 a month on private jet charters and luxury villas in St. Tropez, the attorney has found the thread. In the current year, AI-driven pattern recognition software can scan years of credit card metadata, social media geotags, and public manifests to create a heat map of where the hidden money is actually being spent. But the defense has also leveled up. Historically, the most common domestic tool was the Domestic Asset Protection Trust, or DAPT. States like South Dakota, Nevada, and Alaska realized they could compete with offshore jurisdictions by changing their own laws. South Dakota, in particular, became a domestic powerhouse by abolishing the rule against perpetuities. This allowed attorneys to create dynasty trusts that could theoretically protect assets from creditors and spouses forever. By 2026, the South Dakota trust industry has grown into a multi-trillion-dollar sector. A divorce attorney in New York facing a South Dakota trust must navigate a labyrinth of state laws that are specifically designed to be hostile to out-of-state claims. Case studies from the last decade show a rising trend in the use of high-value physical assets as mobile wealth. This is the art and collectibles loophole. Imagine Michael doesn't put his money in a bank. He buys a rare Basquiat or a collection of high-end watches. These assets are easily moved across borders and are notoriously difficult to value. In a 2026 divorce, the attorney must send appraisers to secure warehouses in Switzerland, known as freeports, where billions of dollars in untaxed and unrecorded art sit in climate-controlled crates. The legal struggle here is over the right of inspection. If the attorney cannot prove the asset exists, they cannot ask the court to value it. We also see the emergence of the private equity trap. In major financial hubs like San Francisco and Boston, much of a spouse's wealth might be tied up in carried interest or capital calls. Historically, these were seen as future, speculative interests that were difficult to divide. However, the modern divorce attorney uses sophisticated financial modeling to argue that these interests have a present value. They look at historical trends of fund performance to demand a buyout of the spouse's share today. This often leads to a valuation standoff where both sides hire competing Ivy League economists to argue over a single percentage point in a discount rate, a difference that can represent millions of dollars in the final settlement. The 2026 landscape has also seen the weaponization of the central bank digital currency, or CBDC. While crypto was once the Wild West, the government's shift toward a digital dollar has given divorce attorneys a powerful new tool: a programmable, traceable ledger. However, this has only pushed the most determined individuals toward privacy coins like Monero or decentralized finance protocols that use zero-knowledge proofs to hide transaction details. The attorney's job in 2026 is to find the on-ramps and off-ramps, the specific moments when the digital wealth touches the traditional banking system. If they can find a single transfer from a Coinbase account to a local utility bill, they can peel back the layers of the entire digital estate. This deep dive into the hidden vault era reveals a fundamental truth about the profession. The divorce attorney is the ultimate auditor of the human ego. They are the ones who must confront the reality that for a certain segment of the population, the desire to win a legal battle outweighs the desire for financial stability. The historical analysis of these tactics shows that as soon as a new hole is plugged by the legislature, the elite legal minds in major cities find a new way to circumvent it. We have moved from the era of hiding cash in a mattress to the era of hiding wealth in the very fabric of the global financial system. But what happens when the fight moves beyond the money? What happens when the assets are secured, but the battle turns toward the most precious and volatile asset of all: the children? In the next part of this deep dive masterclass, we are going to explore the darkest corner of the profession: the rise of the high conflict custody specialist. We will look at the history of parental alienation, the role of court-appointed psychological evaluators, and the terrifying emergence of the silver bullet tactic used to end a case in a single afternoon. The financial war was just the opening act. The psychological war is where the true scars are formed. We will analyze how the modern attorney uses behavioral data and psychiatric experts to build a case that can determine the future of a family for generations to come. The transition from the clinical coldness of financial asset division to the raw, visceral landscape of child custody marks the moment where a divorce attorney in a major U.S. city must shift their persona from a calculating accountant to a master of behavioral psychology. In the high-pressure legal corridors of cities like Chicago, Miami, and Seattle, the psychological war is where the most significant and lasting impacts are felt. Historically, the shift began in the 1970s and 80s as the tender years doctrine, which was a legal presumption that young children should naturally remain with their mothers, was gradually replaced by the best interests of the child standard. This legislative change was a watershed moment for the matrimonial bar. It effectively removed the preset rules and gave attorneys a vast open canvas upon which to paint their version of reality. They were no longer arguing about a simple legal formula. They were arguing about the very nature of human character, fitness, and parental bonding. In this new era, the role of the forensic evaluator became central to the legal strategy. In California, these are often referred to as 730 evaluators, named after the section of the evidence code that authorizes their appointment. In other major hubs like New York or Illinois, they may be called guardians ad litem or child custody evaluators. These are typically licensed psychologists or social workers appointed by the court to investigate the family dynamic and provide a recommendation on custody and visitation. However, the elite divorce attorney does not simply wait for the report. They begin a process of behavioral consulting long before the evaluator ever rings the doorbell. The attorney analyzes historical trends and previous reports from a specific evaluator to identify their underlying biases. For example, if an evaluator in Philadelphia is known to favor the primary breadwinner because they value financial stability, the attorney will lean into that narrative. If the evaluator is known to favor stay-at-home parents, the attorney will focus on the quantity and quality of time spent on homework and extracurricular activities. Imagine if you are a character named Sarah, a software architect living in Seattle in the current year 2026. Sarah is embroiled in a high-stakes custody battle. In 2026, her attorney's preparation involves a level of digital scrutiny that would have been unthinkable 20 years ago. The attorney isn't just reviewing Sarah's parenting schedule. They are deploying AI-driven sentiment analysis tools to scan 10 years of her text messages, emails, and social media interactions with her spouse. This technology identifies patterns of what the legal system calls parental gatekeeping or emotional volatility. If Sarah sent a single frustrated text at 2 a.m. 3 years ago saying she was exhausted and couldn't handle the children, the opposing attorney will use it in 2026 to build a narrative of chronic parental burnout. Every digital interaction is a potential piece of evidence used in a calculated character assassination designed to sway the evaluator's recommendation. One of the most aggressive and controversial moves in the custody playbook is what professionals call the silver bullet tactic. This is a strategy used by some attorneys to gain an immediate, overwhelming advantage at the very start of a case. It involves the filing of an ex parte emergency motion alleging domestic violence or child abuse. In the legal ecosystem of a major city, judges are historically inclined to act out of an abundance of caution. This results in the immediate issuance of a temporary restraining order, which physically removes the other parent from the home and grants the alleging parent temporary sole custody. Once this status quo is established, it can take months or even years of expensive litigation for the other parent to fight their way back to a 50-50 time-sharing arrangement. The divorce attorney knows that the first 48 hours of a high-conflict case often dictate the trajectory of the next 18 years. This is not about the truth of the allegation in the moment. It is about the tactical acquisition of the physical child and the family residence. As these battles intensify, we see the rise of the parental alienation claim. This is a term used to describe a situation where one parent systematically manipulates the child to reject the other parent. In major cities, attorneys have built entire subspecialties around proving or defending against these claims. To build an alienation case, an attorney will hire a specialized psychiatric expert who looks for specific behavioral markers in the child. One common marker is the use of borrowed scenarios, where a child describes an event they didn't actually witness, often using sophisticated adult vocabulary that is inconsistent with their age. The cost for these high-level experts in 2026 can reach $50,000 per case, creating a distinct divide in the American legal system. There is essentially one level of justice for those who can afford to hire the experts to prove alienation, and another for those who cannot. The courtroom in 2026 has become a theater for the battle of the experts. In a contested trial in a city like Phoenix or Dallas, you might see a parade of 4 or 5 different psychologists. There are the court-appointed evaluators, and then there are the rebuttal experts hired by each side to deconstruct the methodology of the original evaluation. This involves a step-by-step technical critique of psychological testing instruments like the MMPI-3, the Minnesota Multiphasic Personality Inventory. The divorce attorney must be proficient enough in psychological theory to cross-examine a doctor on T-scores, validity scales, and the nuances of the Rorschach inkblot test. If the attorney can prove that the evaluator didn't follow the strict American Psychological Association guidelines for child custody evaluations, they can get the entire report thrown out, resetting the clock on the case. The historical data on custody outcomes in major U.S. metropolitan areas shows a fascinating trend. Despite the move toward gender-neutral laws, mothers historically received primary physical custody in the vast majority of cases throughout the 20th century. However, since the year 2000, there has been a 300% increase in the award of 50-50 joint physical custody in cities like Los Angeles and Chicago. This shift is largely due to the work of fathers' rights advocacy groups and the evolution of the divorce attorney into a proponent of the co-parenting model. In 2026, the standard expectation in many urban courts is a 2-2-3 or a week-on, week-off schedule, and an attorney must present compelling evidence of actual harm to deviate from that norm. To prepare for a 2026 custody trial, the attorney follows a rigorous multi-step process. First, they conduct a deposition of the court-appointed evaluator, looking for any procedural errors. Second, they subpoena all the raw testing data, including the handwritten notes of the psychologist. Third, they create a digital timeline of alienation, using metadata from parenting apps like Our Family Wizard to show how one parent consistently blocked communication or rescheduled visits. Fourth, they perform witness preparation with teachers, pediatricians, and neighbors to ensure that the testimony is consistent with the desired narrative. Finally, they compile what is known as the character pack, a curated collection of videos and photos showing the client as the primary, nurturing caregiver in various settings. The complexity of these cases is further increased by the emergence of virtual visitation laws. In 2026, custody orders in cities like San Francisco specifically include provisions for FaceTime, Zoom, or even metaverse visitation. Attorneys must now negotiate digital boundaries, such as which parent is responsible for the child's VR headset and who has administrative control over the child's private social servers. The definition of a visit has expanded from a physical presence to a digital one, and the attorney is the one who must draft the language that governs these interactions. What this deep dive into the psychological war reveals is that the divorce attorney in a major U.S. city is no longer just a legal representative. They are a manager of human behavior. They use every tool from behavioral economics to forensic psychiatry to navigate a system where the stakes are the highest they can possibly be. The history of the profession shows a move toward greater and greater sophistication in how character is measured and how influence is exerted over the court's decision-making process. But as the battle for the children reaches its peak, a new technological force is beginning to change the very foundations of how judges make decisions. While the attorneys are fighting over psychological evaluations, the courtrooms themselves are being integrated into a global data network. In our next part, we will explore the algorithm of justice. We will analyze how major U.S. cities are beginning to use predictive AI to forecast judicial rulings, and how the world's most elite attorneys are using judge analytics to decide exactly when to file a motion and when to settle. The human element of the law is being challenged by lines of code, and in 2026, the most powerful tool in an attorney's arsenal might not be a law book, but a data set. We will look at the rise of the machine learning litigator and the end of judicial unpredictability. The integration of data science into the practice of matrimonial law has effectively turned the courtroom into a laboratory. By the year 2026, the elite divorce attorney in major hubs like New York City, Chicago, and Miami has moved beyond the era of judicial intuition. We are now in the age of the machine learning litigator. This professional shift represents a historical transition where the most valuable asset in a high-stakes divorce is no longer just a persuasive orator, but a comprehensive data set. To understand the depth of this change, we must look at how judge analytics have fundamentally altered the timeline and potential outcomes of modern domestic litigation. Historically, an attorney's knowledge of a judge was based on anecdotal evidence, whispered conversations in the courthouse elevator, and personal experience over 20 years of practice. In 2026, that has been replaced by judicial profiling software that scrapes millions of pages of court dockets and written opinions. Imagine a character named Elena, a high-net-worth individual in Los Angeles. Her attorney is facing a complex dispute over the characterization of a technology patent developed during the marriage. In the past, the attorney would guess how a judge might rule based on the judge's reputation for being pro-business or family first. In 2026, Elena's attorney generates a judicial heat map. This report analyzes every ruling the assigned judge has made in the last decade regarding intellectual property in a marital context. The data reveals a specific pattern. This judge is 70% more likely to characterize a patent as separate property if the initial filing occurred before the date of marriage, even if significant community funds were used to defend that patent during the marriage. With this statistical reality in hand, the attorney doesn't just argue the law, they argue the judge's own historical trends back to them. This is the first step in the 2026 tactical playbook, The elimination of judicial surprise. By knowing the statistical probability of an outcome, the attorney can advise their client with a level of precision that was previously impossible. This isn't a promise of a result, but a calculated analysis of the potential outcomes based on a decade of hard data. This shift has also given rise to a new phenomenon known as the settlement window. Historically, cases often settled on the courthouse steps because the fear of the unknown finally outweighed the desire to fight. In 2026, attorneys use predictive modeling to identify the exact moment when an opposing party is most likely to accept a settlement offer. This software analyzes the financial pressure on both parties, the rising cost of legal fees, and the historical timing of settlements in similar cases within the Los Angeles County Superior Court system. For Elena, the data might suggest that her spouse is 85% likely to settle once the discovery process reaches the 18-month mark and the legal fees exceed $500,000. The attorney then structures their strategy to reach that threshold as efficiently as possible, essentially engineering the conditions for a settlement. Step by step, the process of data-driven discovery has become a digital dragnet. In 2026, the divorce attorney uses AI-powered sentiment analysis on all digital communications. They don't just look for what was said, they look for how it was said. For example, if Elena's spouse frequently used language that indicates a high level of risk aversion in their emails, the attorney will use that information during negotiations. They will present trial as a high-risk, high-volatility event, knowing that the opponent's own psychological profile, as revealed by their digital footprint, makes them more likely to seek a low-risk settlement. This is the professionalization of leverage. Furthermore, the 2026 attorney utilizes litigation simulators. These are private, AI-driven environments where the attorney can run their opening and closing statements against a model of the specific judge's psychological and legal profile. The simulator identifies which legal theories have a higher probability of being accepted, and which trigger words might lead to a negative reaction from the bench. If the judge has a historical tendency to favor arguments rooted in equity over strict statutory interpretation, the simulator will flag any overly technical arguments as high risk. This allows the attorney to refine their narrative in a digital sandbox before ever stepping into the real courtroom. The cost of this technology has created a significant historical divide in the major U.S. cities. We are seeing a bifurcation of the legal market. On one side, you have the data-empowered boutique firms that represent the top 1%. On the other, you have the traditional practitioners who still rely on the old ways of practicing law. The data from 2024 to 2026 shows that the firms utilizing these analytical tools are reaching resolutions an average of 30% faster than their peers. This efficiency is not just about saving time. It is about preserving the marital estate. In high-stakes cases, the burn rate of legal fees can be staggering. By using data to shorten the duration of the conflict, the attorney is performing a vital act of financial preservation for their client. In cities like Chicago, the use of predictive analytics has even begun to influence the way prenuptial agreements are drafted. Attorneys are now using historical data from the last 20 years of Cook County case law to identify which specific clauses are most likely to be overturned and which are historically judge-proof. They are no longer just writing a contract. They are writing a document that is optimized for the local judicial environment. This has led to the rise of the algorithmic prenup, where the terms of the agreement automatically adjust based on the current state of the law in the jurisdiction where the couple resides. However, this reliance on data has also introduced a new form of conflict, the battle of the algorithms. What happens when both Elena's attorney and her spouse's attorney have access to the same judicial analytics? This is where the profession returns to its roots in strategy and human psychology. When the data is a stalemate, the attorney must find a way to break the pattern. This involves a tactic known as judicial disruption. If an attorney knows that a judge's pattern is highly predictable, they may intentionally introduce a novel legal theory or a unique set of facts that the judge's data profile hasn't encountered before. They are essentially trying to reprogram the judge's perception of the case by breaking the statistical mold. This evolution from the 1980s financial auditor to the 2026 data scientist marks the completion of the professionalization of the American divorce. The attorney is now a high-level systems manager, overseeing a complex array of psychological, financial, and digital inputs. They are the pilots of a sophisticated legal machine, navigating through a landscape where every move is tracked, analyzed, and predicted. We have reached a point where the human element of the law is being held to a standard of mathematical accountability that would have been unrecognizable to the divorce attorneys of the Reno era. But as the courtrooms become more predictable and the data becomes more absolute, a new and even more complex frontier is emerging. While the machines can predict how a judge will rule on a patent or a bank account, there is one area that remains stubbornly resistant to the algorithm: the human subconscious and the use of high-level emotional engineering. In our next part, we will look at how the world's most elite attorneys are moving beyond the data and into the realm of neurological persuasion. We will analyze the secret world of jury and judge consultants who use biometric sensors and linguistic programming to influence the decision-makers on a biological level. The war of the data is reaching its limit. The war for the mind is about to begin. We will explore the rise of the neurolitigator and the terrifying possibility that your own biological responses in the courtroom could be used against you in the final judgment. The emergence of neurolitigation in the year 2026 has transformed the high-stakes courtrooms of Miami, Los Angeles, and New York into environments of extreme psychological engineering. We have transitioned from the era of the silver-tongued orator into the era of the neurological architect. In this masterclass of Part 6, we analyze how the elite divorce attorney in a major U.S. city uses the biological vulnerabilities of the human brain to influence the potential outcomes of a case. This is no longer just about the law of the land, it is about the law of the central nervous system. To see this in action, imagine a character named James, a high-profile real estate developer in Miami in the current year 2026. James is navigating a high-net-worth dissolution involving $500 million in multifamily assets. His attorney is not just a legal expert, they are the lead director of a neuroconsulting team. The first step in this tactical evolution is the deployment of the biometric shadow jury. Historically, in the 1990s and early 2000s, wealthy litigants would hire a shadow jury, a group of people matching the real jury's demographics who sat in the gallery and provided feedback to the legal team during breaks. In 2026, this concept has been weaponized with wearable technology. The shadow jury in James's case is equipped with discrete biometric sensors that monitor heart rate variability, skin conductance, and pupil dilation in real time. This data is transmitted to the attorney's tablet, providing a live heat map of which arguments are causing physiological stress or emotional resonance. If the attorney mentions James's contributions to the local community and the shadow jury's collective heart rate drops, indicating a state of calm and acceptance, the attorney knows to lean into that narrative. Conversely, if a technical argument about depreciation schedules causes a spike in skin conductance, indicating confusion or irritation, the attorney immediately pivots to a simpler, more relatable analogy. This biological feedback loop allows the attorney to adjust their performance in the moment, a technique known as physiological pacing. But the strategy goes deeper than just monitoring the audience. In the current year, the most expensive divorce attorneys are using micro-expression analysis to read the judge. While judges are trained to maintain a neutral countenance, the human face cannot fully suppress micro-expressions, involuntary facial movements that last only a fraction of a second. In 2026, AI-enhanced cameras in the courtroom, or even the attorney's own trained eye, look for the subtle wrinkling of the nose that indicates disgust or the slight lift of the inner eyebrow that signals empathy. If the judge shows a micro-expression of contempt when the opposing counsel mentions a specific offshore account, James's attorney will repeatedly circle back to that account, triggering that same negative neurological response in the judge over and over again. This is the professional application of Pavlovian conditioning in a legal setting. Linguistic programming has also reached a new level of sophistication in major U.S. cities. Attorneys are now using a technique called anchoring to tie specific emotions to their opponent. In James's Miami trial, his attorney uses a specific sharp hand gesture every time they mention the word recklessness in relation to James's spouse. They also use a different lower vocal tone. Over several days of testimony, the attorney builds a neurological bridge. Eventually, the attorney can simply make that specific hand gesture or drop their voice into that lower register without even saying the word, and the judge's brain will subconsciously trigger the feeling of recklessness and disapproval. This is a step-by-step process of emotional engineering that bypasses the rational, logical filters of the legal mind. Another critical historical trend in 2026 is the use of the cognitive load strategy during depositions. When James's attorney deposes the opposing party, the goal is not just to get information, but to induce a state of neurological exhaustion. They achieve this by asking questions in a nonlinear fashion, forcing the deponent to constantly shift between different areas of the brain. switching from memory retrieval of 2018 tax records to the emotional processing of child custody schedules. By maintaining a high cognitive load, the attorney forces the deponent into a state of decision fatigue. This is when the most damaging admissions are made, as the brain loses the energy required to maintain a complex, fabricated narrative. The attorney is essentially waiting for the moment when the deponent's prefrontal cortex, the seat of executive function, surrenders to the stress. In the New York legal market, this has evolved into the art of environmental priming. Because many high-stakes mediations in 2026 take place in private law firm offices rather than public courthouses, the attorney has total control over the sensory environment. This includes the use of specific olfactory triggers, scents like sandalwood or cedar that have been shown in clinical studies to lower cortisol levels and increase trust. It includes the temperature of the room. A slightly cooler room has been shown to keep individuals more alert and less likely to become emotionally volatile. Even the weight of the pens provided and the texture of the chairs are selected to prime the opponent for a state of compliance. This is a far cry from the wood-paneled courtrooms of the 1950s. This is the legal system as a controlled laboratory of human behavior. Case studies from 2025 and 2026 show that these neurolitigation tactics have a profound impact on the settlement process. When an opponent realizes that their own biological responses are being monitored and used as leverage, the psychological pressure to settle becomes immense. It creates a feeling of total transparency, where the litigant feels they can no longer hide their true intentions. This is the ultimate goal of the elite divorce attorney in a major city, to win the case before it ever reaches a final judgment by making the alternative too psychologically taxing to endure. We must also consider the role of the neuro-expert witness. In 2026, it is common for an attorney to call a neuroeconomist to the stand to testify about how a spouse's brain is literally wired for financial risk, or a social neuroscientist to explain the biological basis of a parent's attachment style. This moves the argument away from subjective opinions and into the realm of hard science. If an expert can show a brain scan indicating that a spouse has a diminished capacity for empathy, it carries a weight that a dozen character witnesses could never achieve. The attorney uses these scans as the ultimate piece of demonstrative evidence, a window into the soul provided by a multi-million-dollar MRI machine. The historical analysis of this shift reveals a move toward the dehumanization of the legal process in favor of biological certainty. The divorce attorney in 2026 is a technician of the mind, navigating the neural pathways of the judge, the jury, and the opponent with surgical precision. This is the peak of the professionalization of domestic conflict, where the battle is fought in the milliseconds between a thought and a facial movement. But as we master the internal workings of the brain, we must also look at the external forces that shape how the world perceives these high-stakes battles. While the neurolitigator works inside the courtroom, an entirely different team of professionals is working in the digital streets. In our next part, we will explore the rise of the digital reputation architect. We will analyze how the elite divorce attorney in major U.S. cities manages the viral narrative, using bots, influencers, and SEO suppression to ensure that while the case is won in the courtroom, the client's public life is preserved in the court of public opinion. We will look at the secret contracts between law firms and PR giants to create the perfect celebrity archetype, and the terrifying power of the deepfake in modern litigation. The battle for the mind was just the beginning. The battle for the legacy is next. The management of a client's digital legacy has become the modern divorce attorney's most critical external operation. In the high-stakes legal markets of cities like Chicago, Atlanta, and Washington, D.C., the war is no longer contained within the four walls of a courtroom. It has spilled out into the global digital commons. By the year 2026, the elite matrimonial firms in these major U.S. cities have formalized partnerships with what are known as digital reputation architects. These are not traditional publicists. They are high-level data scientists and SEO engineers who treat a client's online presence with the same tactical precision that a general treats a battlefield. This evolution represents a massive historical shift from the 1990s, where an attorney's PR strategy was limited to a well-placed leak in a gossip column. Today, the strategy involves the manipulation of the very algorithms that define reality for the public. To understand how this functions in the current year, imagine a character named Alexander, a prominent venture capitalist in Chicago in 2026. Alexander is navigating a high-profile divorce that involves allegations of corporate mismanagement and personal infidelity. In the 1980s, these details might have been buried in a paper file in the Cook County Clerk's office. In 2026, the moment the petition is filed, automated scrapers identify the case and trigger a cascade of digital alerts. Alexander's attorney does not wait for the press to call. The legacy preservation protocol begins weeks before the filing even occurs. This is a step-by-step process of narrative preemption. The first step is SEO suppression, often referred to by professionals as the forest of noise strategy. The divorce attorney knows that they cannot delete the news of a divorce from the internet. Instead, they hire teams to create an overwhelming volume of positive, high-authority content that pushes the negative news to the second and third pages of search engine results. Historical trends show that 91% of users never click past the first page of results. Alexander's team will launch several new philanthropic initiatives, publish a series of white papers on industry trends, and secure interviews for him on niche tech podcasts. By the time the divorce news breaks, the search algorithm is so saturated with this new curated content that the scandalous headlines struggle to gain traction. The attorney is essentially using the mechanics of the internet to bury the truth in plain sight. In 2026, this has evolved into the use of synthetic consensus. Divorce attorneys in major hubs like Dallas and Miami now utilize AI-driven bot farms to shape the sentiment of the digital discourse. If a spouse's legal team leaks a damaging document, Alexander's reputation architects deploy a fleet of sophisticated AI personas to flood the comment sections of news sites and social media platforms. These bots do not use crude or obvious language. They are programmed to mirror the speech patterns of rational, middle-class observers. They might express skepticism about the timing of the leak or redirect the conversation toward the spouse's own financial history. This creates a statistical illusion of public support, which is critical because judges and their clerks, despite their professional training, are not immune to the atmospheric pressure of public opinion. Historical data from the early 2020s indicated that high-conflict cases were increasingly being decided in what attorneys call the court of social media. By 2026, this has become an exact science. The attorney monitors the digital sentiment in real time using heat maps that track how specific allegations are being received by different demographics. If the data shows that female professionals in the Chicago suburbs are responding negatively to a specific piece of evidence, the attorney will immediately adjust their courtroom narrative and their digital output to counter that specific perception. This is a continuous feedback loop between the legal strategy and the digital architecture. The most terrifying frontier in 2026 litigation is the emergence of synthetic evidence, more commonly known as deepfakes. In a major city divorce case today, an attorney must assume that any piece of digital evidence, a voice memo, a video from a doorbell camera, or a series of text messages, could be a sophisticated fabrication. Alexander's case might involve a leaked video of him in a compromising situation. His attorney's first move is not a legal denial but a forensic audit. They employ experts who analyze the metadata and look for neurological inconsistencies in the video, such as mismatched pupil dilation or unnatural microexpressions. Historically, the legal system was slow to adapt to digital evidence, but in 2026, the burden of proof has shifted. Every piece of incriminating digital media is treated as guilty until proven authentic. This has led to the rise of the digital alibi service. Some high-net-worth individuals in 2026 now pay for services that continuously record their location and biometric data, creating a verified digital trail that can be used to debunk false allegations in a divorce. Alexander's attorney will use this data to show that he was in a board meeting at the exact time a deepfake video claims he was elsewhere. This is the professionalization of the anti-deepfake defense, a tool that has become standard in the arsenal of the world's most expensive matrimonial firms. Case studies from the last 24 months show a rising trend in the use of strategic distraction. This is a tactic where the divorce attorney intentionally leaks a minor, non-legal controversy to draw the public's attention away from a much more damaging financial or legal reality. In Alexander's case, his team might leak a story about a dispute over the custody of a high-value show horse. While the public and the tabloids obsess over the fate of the animal, the legal team quietly settles a multi-million-dollar dispute regarding offshore corporate shells. This is the art of the intentional vacuum, where the attorney controls what the public sees by giving them something else to look at. Furthermore, the divorce attorney in 2026 must manage the threat of digital extortion. In major U.S. cities, a new class of digital mercenaries has emerged who specialize in mining the private data of wealthy spouses and threatening to release it during a divorce. The elite attorney acts as a negotiator in these dark web interactions, working with cybersecurity firms to identify the source of the threat and, if necessary, using legal and technical countermeasures to neutralize the data before it can be used as leverage. This is a far cry from the private investigators of the 1950s who sat in cars with telephoto lenses. This is a high-speed cyber war. The historical analysis of this evolution shows that the definition of a successful divorce has changed. It is no longer just about the division of assets or the custody of children. It is about the preservation of the client's ability to function in the professional and social world after the case is closed. For a character like Alexander, a victory in court is meaningless if his reputation is destroyed in the process. He would lose his investors, his board seats, and his future earning potential. This is why the 2026 attorney spends as much time on the digital legacy as they do on the legal brief. They are the guardians of the persona, ensuring that the client emerges from the wreckage of their marriage with their public dignity intact. By studying these historical trends, we see that the divorce attorney has become the ultimate gatekeeper of information. They decide what the judge sees, what the public believes, and what the internet remembers. We have moved into an era where truth is a managed asset, and the most successful practitioners are those who can navigate the digital architecture of the modern world with the most sophistication. But as we master the digital legacy and the synthetic narrative, we are forced to confront the final and most immutable reality of the legal system: the judge's chambers. While the public can be manipulated and the assets can be hidden, the final decision still rests in the hands of a single human being, often operating under immense personal and political pressure. In the next part of this deep dive masterclass, we will look at the secret world of judicial politics in major U.S. cities. We will analyze how the elite divorce attorney manages the judge outside of the courtroom, looking at the history of campaign contributions, social networking, and the subtle art of judicial influence that defines the upper echelons of the American legal system. The digital war is for the public, the political war is for the result. We will explore the rise of the kingmaker attorney and the hidden mechanisms of power that ensure the desired outcome long before the first motion is ever argued. The judicial system in major United States cities is often perceived as a sterile environment where logic and statutes dictate every outcome, but a historical analysis of the top-tier divorce attorney reveals a far more complex reality. To understand the political war for the result, we must examine the specific mechanics of how judges are seated in cities like Chicago, Houston, and Philadelphia. Unlike the federal bench, where judges are appointed for life, many state-level judicial positions in major metropolitan areas are determined through popular elections or retention votes. This creates a historical trend where the judiciary is not an isolated ivory tower, but a vibrant, and sometimes volatile part of the local political machine. For the elite matrimonial lawyer, navigating this landscape is a prerequisite for high-stakes litigation in 2026. Historically, the connection between the bench and the bar in cities like Chicago has been defined by the party slate. In the mid-20th century, a lawyer hoping to become a judge often needed the blessing of the local political ward leaders. Once on the bench, these judges were frequently up for retention, meaning they had to maintain a level of public and professional approval to keep their seats. This is where the kingmaker attorney enters the frame. These are not just practitioners of law. They are the individuals who chair the judicial evaluation committees and manage the campaign funds that keep judges in office. When a high-net-worth individual enters a divorce in 2026, they aren't just hiring a litigator. They are often hiring a person whose firm has provided the financial and organizational backbone for the very judge presiding over the case. Imagine a character named Christopher, a commercial developer in Atlanta in the current year 2026. Christopher is facing a divorce that involves the valuation of several skyscraper projects currently under construction. His case is assigned to a judge who is facing a difficult re-election campaign in the next cycle. Christopher's attorney is a senior partner at a firm that historically contributes 30% of the total donations to that judge's campaign committee. This is not a scenario of direct bribery, which is a violation of legal ethics and criminal law. Instead, it is an analysis of professional presence. The judge knows this attorney. They have seen them at every bar association fundraiser, every local charity gala, and every holiday party for the last 20 years. There is a deep historical layer of institutional trust. In the high-pressure environment of 2026, where a judge must make a split-second decision on a temporary restraining order or a multi-million-dollar asset freeze, that trust acts as a powerful, unspoken weight on the scale. Step by step, the attorney builds this influence through the judicial evaluation process. In major cities, local bar associations issue ratings for judges, categories like highly recommended, recommended, or not recommended. The attorneys who sit on these evaluation boards hold the professional life of a judge in their hands. A negative rating from a powerful bar association can be a death sentence for a judicial career. Consequently, a historical analysis shows that judges in urban centers are often acutely aware of the professional standing of the attorneys appearing before them. If an attorney is a known leader in the bar, their legal arguments are often granted a higher degree of initial credibility. This is the professionalization of reputation, where the attorney's status within the legal community becomes a strategic asset for the client. By the 1990s, this reached a new level with the rise of judicial PACs or political action committees. These organizations allowed law firms to pool their resources and influence judicial races on a massive scale. Historical data from Texas and Ohio in the early 2000s showed a high correlation between the top donors to a judge's campaign and the firms that frequently appeared in their courtroom. For the 2026 matrimonial specialist, this means managing a delicate balance of public support and private advocacy. They must ensure that their firm is seen as a pillar of the legal establishment, while maintaining the rigorous ethical boundaries required by the model rules of professional responsibility. The social engineering of the bench extends into the realm of judicial education. Elite law firms often sponsor legal seminars and conferences where judges are invited to speak or attend as guests. In 2026, these are frequently held at luxury retreats or high-end urban clubs. While the content of the seminars is strictly educational, the environment allows for informal networking that builds a shared worldview. When an attorney and a judge spend 3 days discussing the historical trends of equitable distribution in a scenic mountain setting, they develop a common language and a mutual understanding of the complexities of the law. This shared philosophy often translates into more predictable potential outcomes for the attorney's clients back in the city. In 2026, we also see the digital transformation of judicial politics. Attorneys now use data analytics to monitor a judge's public sentiment and social media footprint. They can identify the specific local issues that a judge is most concerned about, perhaps a recent spike in local housing costs or a specific cultural trend in the city. The attorney then subtly weaves these themes into their courtroom arguments. For Christopher in Atlanta, his attorney might emphasize how the stability of his development projects is essential for the city's post-2025 economic recovery, knowing that the judge has recently made public statements about the importance of urban revitalization. This is the art of alignment, where the legal case is framed to resonate with the judge's broader political and social priorities. Furthermore, the role of the kingmaker attorney involves the management of judicial clerkships. The elite firms in cities like New York and Los Angeles often serve as a pipeline for the brightest young legal minds to become clerks for the top matrimonial judges. These clerks are the ones who perform the initial research and draft the preliminary opinions. A historical analysis of the most influential firms shows that many of their senior partners were once clerks in the very courts where they now practice. This creates an institutional memory and a network of relationships that spans generations. The attorney doesn't just know the judge. They know the clerk, the court reporter, and the bailiff. They understand the internal culture of the courthouse, the specific preferences for brief formatting, the judge's tolerance for aggressive cross-examination, and the exact time of day when a judge is most receptive to a complex financial argument. As we analyze these case studies from the last 30 years, we see that the political war for the result is essentially a war for familiarity. The human brain is biologically wired to favor the familiar over the unknown. By positioning themselves as an indispensable part of the judicial ecosystem, the top divorce attorney in a major U.S. city reduces the friction of the legal process. They ensure that their client is not seen as a stranger in a cold system, but as a person represented by a trusted and respected figure in the community. This historical progression from the party-line politics of the 1950s to the data-driven social engineering of 2026 illustrates a profession that has mastered the mechanics of power. But even as the attorney masters the local political landscape, a new and even more complex challenge is rising. While the local judge can be managed, the assets themselves are increasingly moving beyond the reach of any single city's jurisdiction. In the current year, we are seeing the emergence of the globalized divorce, where a single case can involve properties in London, crypto vaults in Singapore, and trusts in the Cayman Islands. In the next part of this deep dive masterclass, we will explore the international shadow play. We will analyze how the world's most elite divorce attorneys coordinate with foreign counsel to launch multi-jurisdictional strikes, using international treaties and secret asset tracing networks to corner an opponent across the globe. The local political war was just the foundation. The global chess match is where the true empires are won or lost. we will look at the rise of the sovereign matrimonial litigator and the end of the traditional jurisdictional border. The dissolution of borders in the high-stakes legal world has given rise to the sovereign matrimonial litigator, a legal professional whose office in a major U.S. city functions more like a global intelligence agency than a traditional law firm. In 2026, the historical trend of the global nomad has reached its peak. The wealthiest individuals in cities like San Jose, Seattle, and Miami no longer hold their wealth in a single jurisdiction. Their lives are a complex tapestry of international interests: a primary residence in California, a family office in Singapore, a tech hub in Tel Aviv, and offshore holding companies in the Cayman Islands. To represent these individuals, the modern divorce attorney must master the international shadow play, a step-by-step process of multi-jurisdictional strikes designed to corner an opponent before they can realize they are under attack. Imagine if you are a character named Catherine, a high-level executive at a global artificial intelligence firm in San Francisco in the current year 2026. Catherine has discovered that her spouse, who manages a private equity fund, has been systematically moving marital assets into a series of non-custodial digital vaults and luxury real estate holdings in Dubai and the Seychelles. In the 1990s, Catherine's attorney might have struggled to even serve process on a spouse across borders. In 2026, the sovereign litigator begins with a tactical maneuver known as the forum shopping strike. This is the art of selecting the specific legal jurisdiction that offers the most favorable potential outcomes for the client. Historically, London became known as the divorce capital of the world because English courts were perceived to be more generous toward the non-earning spouse. However, in 2026, the San Francisco attorney must weigh the benefits of California's community property laws against the speed and secrecy of the international financial centers. The first step in Catherine's 2026 strategy is the filing of an anti-suit injunction. This is a high-level legal tool where the San Francisco court issues an order prohibiting the spouse from commencing or continuing divorce proceedings in another country. Historically, this has been the primary weapon in the jurisdictional war. If Catherine's spouse files first in a jurisdiction that does not recognize equitable distribution, she could lose access to hundreds of millions of dollars. The attorney's goal is to lock the case into the U.S. court system, which has a historical trend of being more aggressive in its discovery powers and more willing to pierce the corporate veil of offshore entities. This leads to the second phase of the 2026 global chess match, the International Asset Tracing Network. The elite divorce attorney in a major U.S. city no longer works in isolation. They are part of a secret world of international legal cooperatives. Within minutes of being retained, Catherine's attorney activates a global network of forensic accountants and digital investigators. They utilize the 2026 iteration of the Common Reporting Standard, a global information sharing agreement that allows for the automatic exchange of financial account information between over 100 countries. However, because Catherine's spouse is using decentralized finance protocols, the attorney must go deeper. They employ blockchain forensic firms to perform a cluster analysis, identifying the specific digital signatures associated with the spouse's hidden vaults. The historical trend shows that while assets can be moved instantly, the digital footprint they leave behind is permanent. The attorney's task is to connect those footprints to the spouse's identity with a level of certainty that will satisfy a judge in a San Francisco courtroom. Case studies from 2024 to 2026 highlight the rising importance of the 1980 Hague Convention on the civil aspects of international child abduction. In the world of the sovereign litigator, the most terrifying multi-jurisdictional strike involves the children. Imagine if Catherine's spouse, sensing the impending legal battle, takes the children on a vacation to a non-signatory country and refuses to return. Historically, this was a legal black hole. In 2026, the attorney must immediately engage the U.S. Department of State and local law enforcement in the foreign jurisdiction. The step-by-step process involves filing a Hague petition, which requires proving that the children were habitually resident in the U.S. and that the removal was a breach of Catherine's custody rights. The 2026 attorney uses metadata from the children's wearable devices and school portals to establish their habitual residence, creating a digital proof of life that foreign courts find difficult to ignore. Furthermore, we must analyze the role of the Foreign Sovereign Immunities Act or FSIA. In major U.S. cities like Washington, D.C. or New York, divorce attorneys frequently represent individuals married to foreign diplomats or officials with state-connected wealth. This introduces the concept of sovereign immunity, a historical legal doctrine that protects foreign states and their officials from being sued in U.S. courts. In 2026, the matrimonial litigator must be an expert in the exceptions to the FSIA. They must argue that the assets in question are not state property, but are held for private, commercial purposes. This requires a granular historical analysis of the source of the funds. If the attorney can show that the luxury Manhattan penthouse was purchased with funds from a private investment account rather than a state treasury, they can bypass the immunity defense. This is the peak of legal complexity, where a domestic relations case becomes a matter of international diplomacy and federal law. The 2026 landscape has also seen the emergence of the International Freeze Order, also known as a Mar-Eva injunction. This is a worldwide order that prevents a party from dissipating assets regardless of where they are located. For Catherine, her attorney obtains an order from a San Francisco judge that is then domesticated in foreign courts through a process of international comity. This requires a network of local counsel in every jurisdiction where the assets are suspected to be held. The coordination of these local firms is a logistical masterpiece. The San Francisco attorney acts as the central command, ensuring that the freeze orders are served simultaneously across different time zones to prevent the spouse from moving the money as soon as the first order is served. This is what we call the global lockdown. The historical data on international divorce indicates that the cost of these battles is often prohibitive for all but the top 0.1%. In 2026, the average cost of a multi-jurisdictional divorce in a major U.S. city can exceed $5 million in legal and forensic fees alone. This has created a secondary market for litigation funding, where specialized firms provide the capital for the legal battle in exchange for a percentage of the final settlement. The divorce attorney in 2026 must now also be a fundraiser and a risk assessor, convincing these funding firms that the potential outcomes of the case justify the massive upfront investment. This deep dive into the international shadow play reveals that the divorce attorney has evolved into a global strategist. They are the ones who understand that in a world of digital wealth and mobile elites, the traditional jurisdictional border is an illusion. The history of the profession is a move toward the integration of domestic law with the complexities of global finance and international treaties. The sovereign matrimonial litigator is the person who can look at a map of the world and see not just countries, but a series of interconnected legal opportunities and risks. As we conclude this analysis of the global chess match, we see that the battle for the assets, the children, and the legacy has been fought across every possible dimension: financial, psychological, digital, political, and international. We have seen how the attorney in a major U.S. city has become an architect of the modern family's dissolution and reconstruction. But as the 2026 landscape continues to shift, one final question remains. What is the endgame? When all the data has been analyzed, all the assets traced, and all the judges influenced, what is the final state of the American divorce? In our 10th and final part of this masterclass, we will look at the legacy and the future. We will explore the rise of the post-legal resolution and the emergence of the AI arbiter. We will analyze the historical trajectory to its ultimate conclusion and reveal what the next 50 years of the profession will look like. The journey through history is almost complete. The revelation of the future is next. The final transformation of the matrimonial legal profession in the year 2026 is defined by a shift from high-conflict litigation toward what we now call algorithmic resolution. For over a century, the divorce attorney in major U.S. cities like New York, Chicago, and Los Angeles functioned as a combatant in a zero-sum game. However, a significant historical trend has emerged where the sheer volume of data, the cost of expert witnesses, and the multi-year backlogs in urban court systems have made traditional litigation unsustainable for even the most affluent clients. This has paved the way for the rise of the AI arbiter and the private court system, a development that represents the ultimate conclusion of the professionalization of the industry. To understand the endgame, we must look at how the role of the attorney is being redefined as a systems architect rather than a trial lawyer. Imagine if you are a character named Benjamin, a high-level biological engineer living in a tech-integrated district of Denver in the current year 2026. Benjamin and his spouse have decided to dissolve their marriage, but they possess a complex portfolio of synthetic assets, carbon credit offsets, and fractionalized real estate interests. In the 1990s, this case would have spent 5 years in the Colorado judicial system, with attorneys arguing over valuations until a significant portion of the estate was consumed by fees. In 2026, Benjamin's attorney does not file a standard petition in a public courthouse. Instead, the attorney initiates a decentralized justice protocol. This is a step-by-step process where both parties agree to submit their financial data, digital footprints, and even their biometric compatibility profiles to a neutral high-performance AI arbiter. The AI arbiter functions as a private digital judge. It analyzes decades of historical trends in Denver's domestic relations cases, cross-references those with current market valuations of Benjamin's specific assets, and generates a resolution proposal in a matter of hours. The role of the divorce attorney in 2026 is to act as the programmer and advocate within this digital sandbox. They are not arguing before a human judge. They are auditing the algorithm's logic. Benjamin's attorney must ensure that the AI is not weighing certain variables, like the volatility of his carbon credits, with an outdated bias. This is the professionalization of oversight. The attorney has moved from the courtroom floor to the data center, ensuring that the machine's output aligns with the most recent legislative shifts and historical precedents. This historical trajectory reveals that the divorce attorney has effectively become a manager of automated equity. In the 1980s, the battle was over who got the house. In 2026, the battle is over the logic of the code that decides who gets the house. We see this most clearly in the rise of the smart prenuptial agreement. Historically, a prenup was a static document that often became obsolete as a couple's wealth grew or their residency changed. In 2026, the elite firms in major U.S. cities draft dynamic contracts. These are blockchain-based agreements that automatically update in real time. If Benjamin moves from Denver to Miami, the contract's jurisdictional clauses automatically adjust to reflect the potential outcomes of Florida's specific statutes. The attorney's role is to maintain this digital contract throughout the marriage, acting as a proactive risk manager rather than a reactive litigator. The economic impact of this shift is staggering. A historical analysis of the U.S. legal economy shows that matrimonial law was once a fragmented local business. By 2026, it has become a centralized, technology-driven industry. The top firms in major cities have essentially become fintech companies with a legal license. They no longer charge by the hour, they charge by the complexity of the asset architecture they manage. The billable hour, a staple of the profession since the early 20th century, is being replaced by value-based pricing models in the upper echelons of the market. This change is driven by the client's demand for efficiency. In Benjamin's case, he is willing to pay a premium for a resolution that takes 48 hours rather than 48 months, because he understands that time is his most valuable non-marital asset. Furthermore, we must analyze the role of the human in the loop. While the AI can handle the math and the law, it cannot handle the human spirit. In 2026, the most successful divorce attorneys in cities like Boston and Austin are those who specialize in emotional engineering and high-level negotiation within the digital framework. They are the ones who can step in when the algorithm hits a stalemate, usually in matters of child custody or the division of sentimental property. The attorney uses the data provided by the AI as a baseline for a human-to-human negotiation, moving the parties from the rigid logic of the machine toward a more nuanced, empathetic resolution. This is the hybrid model of the future: machine-driven efficiency paired with human-led diplomacy. Case studies from the last 12 months show that these private post-legal resolutions are now becoming the standard for the top 1%. By keeping the case out of the public record, the attorney preserves the client's digital legacy and prevents the viral narrative from ever taking hold. In 2026, privacy is the ultimate luxury. The divorce attorney is the gatekeeper of that privacy, ensuring that the details of Benjamin's life never touch a public docket. This has led to the creation of a tiered justice system in America: a public slow-moving system for the many, and a private high-speed algorithmic system for the few. As we look toward the next 50 years, the historical trend suggests that the divorce attorney will eventually move into the realm of predictive prevention. With the integration of biometric data and relationship analytics, firms in 2030 and beyond may offer services that identify the statistical probability of a marriage's failure years in advance. The attorney will not be there to handle the end. They will be there to manage the transition. We are moving toward a world where the dissolution of a partnership is as standardized and predictable as the closing of a real estate deal. The volatility and the war that define the 20th century divorce attorney are slowly being engineered out of the system in favor of technical precision. The story of the divorce attorney in U.S. major cities is the story of the professionalization of human transition. From the shady hotel rooms of the 1920s Reno colonies to the high-frequency digital courtrooms of 2026, the goal has always been the same: to navigate the gap between who we were and who we want to become. By studying this history, we gain more than just a legal education. We gain a blueprint for how power, wealth and identity are redistributed in a rapidly evolving society. We have seen how the attorney has mastered the financial, the psychological, the digital, and the political to become one of the most powerful figures in the American urban landscape. But even as we conclude this masterclass on the history of the profession, a final deeper mystery remains. While we have analyzed the mechanics of the law and the tools of the trade, there is an entire shadow history of cases that were never filed, resolutions that were handled outside of any known legal or digital framework. There is a hidden network of elite advisors who operate in the spaces between the laws of different nations, managing the world's most powerful families with a set of rules that have never been written down. What are the secret treaties of the ultra-elite? How do they resolve conflict when even the AI arbiter is not trusted? In our final, unscripted conclusion, we will briefly touch upon the emergence of the post-sovereign advisor, the person who sits above the divorce attorney in the hierarchy of global power. The deep dive into history is over, but the investigation into the hidden future of global power is only beginning. We have reached the end of the script, but the implications of what we have uncovered will resonate for decades to come.